Navales v. Abaya, GR numbers 162318 and 162341, October 25, 2004. Opponent D. Justice Galiho, Sr. Petition for habeas corpus and petition for prohibition under Rule 65. Facts. Petitioners are First Lieutenant Navales, et al. And Captain Riaso, et al. Respondents in the two petitions are General Narciso Abaya, who, as Chief of Staff of the AFP, exercises command and control over all the members and agencies of the AFP, and Brigadier General Mariano Sarmiento, Jr., the Judge Advocate General of the AFP and officer in command of the Judge Advocate General Office, the agency of the AFP tasked to conduct the court-martial proceedings. Background: at past 1 a.m. of July 27, 2003, more than 300 junior officers and enlisted men took over the Oakwood Premier Apartments. The group was led by Navy Lieutenant Sergeant Antonio Trillanes IV, Army Captain Gerardo Gambala, Army Captain Milo Mastrecampo, Navy Lieutenant Sergeant James Layug, and Marine Captain Gary Alejano. They aired their grievances against the administration of PGMA and the graft and corruption in the military. They declared their withdrawal of support from the chain of command and demanded the resignation of key civilian and military leaders. Series of negotiations ensued between the soldiers and the government. An agreement was forged at 9:30 p.m. Shortly thereafter, PGMA announced that the occupation of Oakwood was over. Case filed. Information was filed with the RTC Makati charging 321 soldiers with the crime of coup d'état. The case was referred to RTC Branch 61. Petitioners filed an omnibus motion with RTC 61 praying that the court assume jurisdiction over all the charges filed before the military tribunal in accordance with Republic Act No. 7055. While the said motion was pending resolution, the Dodge issued a resolution finding probable cause for coup d'état against only 31 of the original 321 accused. Consequently, an amended information was admitted by the RTC 61 charging only 31 soldiers. This case was eventually consolidated with another case pending before the RTC Branch 148. Case against the other 290 accused, including those who are subject of the petition for habeas corpus, was dismissed. However, First Lieutenant Navales, et al. And Captain Riaso, et al. Were charged before the General Court-Martial with violations of the Articles of War. Meanwhile, RTC 148 acting on the omnibus motion issued an order declaring that, 1. In view of the order of RTC 61, the petition was considered already moot and academic because the accused who filed the same were no longer being charged with coup d'état under the amended information. 2. All charges before the court-martial against the 31 accused as well as those former accused are hereby declared not service-connected, but rather absorbed and in furtherance to the alleged crime of coup d'état. 2 petitions were then filed before the Supreme Court, both assailing the jurisdiction of the General Court-Martial to conduct the court-martial proceedings. 1. A petition for habeas corpus seeking the release of the junior officers and enlisted men of the AFP. The other, a petition for prohibition seeking to enjoin the General Court-Martial from proceeding with the trial of the petitioners and their co-accused for alleged violations of the Articles of War. Petitioners' arguments. 1. Under Republic Act No. 7055, the respondents and the General Court-Martial are without any jurisdiction to further conduct proceedings against the petitioners and their colleagues because the Regional Trial Court has already determined that the offences are not service-related and are properly within the jurisdiction of the civilian courts. 2. The respondents have no authority to further detain the junior officers and enlisted men, as the charges for coup d'état before the regional trial court have been dismissed for lack of evidence upon motion of the Department of Justice. Respondents' arguments. 1. RTC 148 order, particularly Order Number 2, is null and void. At the time the said motion was resolved, petitioners First Lieutenant Navales, et al., and Captain Riaso, et al., as movants therein, were no longer parties in the case, as the charge against them was already dismissed by the RTC 61. The charges against First Lieutenant Navales, et al., and Captain Riaso, et al., filled with the General Court-Martial, that is, violations of the Articles of War 63, 64, 67, 96 and 97, are, in fact, among those declared to be service-connected under the second paragraph of Section 1 of Republic Act No. 7055. This means that the civil court cannot exercise jurisdiction over the said offences, the same being properly cognizable by the General Court-Martial. Thus, the RTC 148 acted without or in excess of jurisdiction when it declared in its order that the charges against those accused before the General Court-Martial were not service-connected, but absorbed and in furtherance of the crime of coup d'état. 2. They were denied of due process, as they were not given an opportunity to oppose or comment on the omnibus motion. Issue: whether or not the petitioners are entitled to the writs of prohibition and habeas corpus. Held, with regard to the writ of prohibition, no, as the General Court-Martial has jurisdiction over charges filed against the petitioners. With regard to the writ of habeas corpus, also no, as they are already charged before the General Court-Martial and under detention pursuant to the commitment order issued by the Chief of Staff of the AFP pursuant to the Articles of War. RTC 148 Order Number 2 is null. It is a superfluity and cannot be given effect. Why? Because RTC 148 acted in excess of its jurisdiction when it declared that, quote, all charges before the court-martial against those former accused are not service-connected but rather absorbed and in furtherance to the alleged crime of coup d'état, end quote. RTC 148 already declared that the omnibus motion had already been rendered moot and academic with respect to First Lieutenant Navales, et al., and Captain Riaso, et al., by reason of the dismissal of the charge of coup d'état against them. If this is the case, then the charges against them, which again are already been dismissed, cannot be ruled as not service-connected. Such declaration was made in violation of Section 1 of Republic Act No. 7055. There was no factual and legal basis for the RTC 148 to rule that violations of Articles 63, disrespect toward the President etc., 64, disrespect toward superior officer, 67, mutiny or sedition, 96, conduct unbecoming an officer and a gentleman, and 97, general article, of the Articles of War were committed in furtherance of coup d'état and, as such, absorbed by the latter crime. Hence by still making such declaration, RTC 148 unlawfully divested the General Court-Martial of its jurisdiction over those said crimes, which under paragraph 2 section 1 of Republic Act 7055 are considered service-connected crimes. Note: Section 1 of Republic Act No. 7055 provides, quote, Section 1. Members of the Armed Forces of the Philippines and other persons subject to military law, including members of the Citizens Armed Forces geographical units, who commit crimes or offenses penalized under the Revised Penal Code, other special penal laws, or local government ordinances, regardless of whether or not civilians are co-accused, victims, or offended parties, which may be natural or juridical persons, shall be tried by the proper civil court, except when the offense, as determined before arraignment by the civil court, is service-connected, in which case the offense shall be tried by court-martial, provided that the President of the Philippines may, in the interest of justice, order or direct at any time before arraignment that any such crimes or offences be tried by the proper civil courts." End quote. As used in this section, service-connected crimes or offences shall be limited to those defined in Articles 54 to 70, Articles 72 to 92, and Articles 95 to 97 of Commonwealth Act No. 408, as amended. Decision: the two petitions are dismissed.